I'm afraid of asking this question because if I ask it, that could be a whole podcast unto itself, gentlemen. If more matters go before religious courts, don't you run into sort of issue of separation of church and state? You can see I'm Dr. Lurie and Dr. Fuchs. It's a pleasure to have you on our program. Thank you for taking the time for this conversation with me. Let's start our conversation with some basics about Israel's Supreme Court. I'll begin with this one that I've been curious about. Does Israel's Supreme Court function under common law, such as in the United States, or civil law, such as in France, or perhaps Jewish legal traditions?
Well, the Israeli Supreme Court has, at its basis, a common law system. It sprung from the British mandate over Palestine, which later became Israel. And at its base are common law traditions. That said, there are a lot of influences and the functionings of the Supreme Court. Again, from the start, you could see even when it was established in September of 1948, the first oaths of office for the justices had to be written and from nothing, and they came back to biblical sources and tried to connect the so to speak the traditions of the Bible to the new Supreme Court and try to make some continuity there.
Interesting.
And also a lot of civil law traditions, particularly in the way of the administration, because a lot of the first justices of the Supreme Court in the first decade, and particularly in the Ministry of Justice, the administration, the early administration of Israel, a lot of people came from continental Europe and particularly from Germany. And
Oh,
so a
interesting.
lot of influences in the way how they perceive that a Supreme Court should be administered and should be related to the Ministry of Justice came from a German perspective of how a Ministry of Justice should tinker with the administration of the courts, also the Supreme Court.
Dr. Fuchs, your colleague, Dr. Lurie, used the word influences, and he talked about the oath. Do Israel's Supreme Court decisions cite the Bible or Hebrew traditions, the Torah, or anything like that?
Sometimes, because some of the justices like to cite Jewish law, and you have to know that we do have some kind of a law that says first you go to the Israeli law, then you go to precedents, and then you go to analogies. And if you don't have any source of law, you can also get some influence from the Jewish law. So it more goes to the tradition of the specific justices. I think some of which we call them judges, some of the judges have a lot more background and they like it and it's part of their tradition. So they cite the Jewish law, but some of them don't.
I read somewhere, and correct me if I'm wrong, that when it comes to family matters, family law, specifically marriage and divorce, religious institutions have their own courts. So let's say if I'm a Muslim Israeli or a Jewish Israeli, I go to completely separate courts. Is that true?
It's true. Some of the status law in Israel, which relates to marriage and divorce and a few other issues of status, are only and totally in the hands of the religious courts. But we do have family courts which are secular, and it's very complicated. Some of the issues that are not about just the divorce itself, for example, the issues of the kids and the issues of the divorce, separation of the
property.
money, the property. So that can be also be dealt with in the secular family courts.
That does sound complicated. So do you go to two separate courts? Let's say you're a rich couple and unfortunately you're getting a divorce. One of the spouses is Orthodox Jewish. I'm making this up as I go along here. And he wants to go, or she wants to go to an Orthodox Jewish tribunal court, but the other spouse wants to go to a civil court, or a government based court. Is that a conflict? Do you run to these issues?
It's very complicated, but the divorce itself can only be done in the Jewish or the religious court.
I see.
The other things which are related to the divorce can be done either in the religious court and either in the secular court. And actually, there is one bill now that is dealing with this issue specifically. They want to give more
I'm glad I asked them.
Religious court. They want to give more power to the religious court. And this is one of the laws that the seculars and specifically women in Israel are worried about, because they feel, and I think rightly so, that the religious court is given less power and rights for the women when they go there, and they want to most of them want to go and deal with all the civil issues about divorce in the secular court.
I'm afraid of asking this question because if I ask it, that could be a whole podcast unto itself, gentlemen. If more matters go before religious courts, don't you run into sort of issue of separation of church and state? You can see I'm asking that from an American perspective, right?
It's not sort of. It is an issue of separation of religious and state. We are fighting with this issue since the beginning of Israel. And it is a big deal. It's not just about that. It's about many other things, about how the Shabbat, do you have public transportation in Shabbat? What about kosherness? What about...
I'm sorry, Dr. Fuchs, I didn't get your comment about public transportation. What does this have to do with public transportation? Religious course?
No transportation during Saturday. And
all
of the secular people, or at least a big majority of them, do want public transportation. If you don't have your own car, you can get anywhere on Saturday. So this is an issue, separation of religion and state.
There are highly technologically advanced and industrial parts of Israel that I know about. For example, let's say Haifa. I know a lot of medical device and biotech companies are in Haifa. It shuts down on Saturday. I'm not complaining. I'm just trying to figure it out. So there's no public transportation in Haifa.
Yes, even though Haifa is really an exception that has some lines are working in Haifa, but not in Tel Aviv, not in Jerusalem, not in Beersheba, not anywhere.
That's fascinating. Wow. I told you I was afraid of asking this question. You can see how we can talk about this for hours. Does Israel's Supreme Court have investigative powers, or does or does it have to wait for parties to bring a case to it? Do you see the difference in the situations?
Well, it has to wait for parties to bring cases to it.
I see.
It's the court of final venue in terms of hearing appeals from parties from lower courts, and it's actually a first appeal, even first instance appeal. And it's also a court that receives direct petitions from parties, sitting as a high court of justice. Meaning that, but again, it has to wait for the parties to submit their petitions in order for the court to hear the case.
Similar to the United States, there are countries whose courts are function a little bit different. They're more hands-on, such as in France.
Right, but it's an adversarial system, and again, it's as in the U.S., it's an adversarial system, and you have to, the parties are responsible for bringing the evidence, particularly in petitions to the High Court of Justice, it's the petitioner who has to bring an affidavit saying that what he says, argues is true, and the state usually answers again with an affidavit, and it's most of the process based on what the parties bring to the court.
Similar to the U.S., we are an adversarial system as well. I appreciate and I understand that Israel's Supreme Court's decisions are binding. I get that. But what if the government doesn't enforce those decisions? We've actually had that history in the U.S., particularly before the Civil War. States would not, from time to time, enforce the Supreme Court's decision. Well, what happens then?
Well, there have been cases in which the government, let's say, dragged its feet and failed to enforce decision, particularly in cases involving the in the West Bank. But there weren't flagrant cases of the government not complying with decisions. They usually drag their feet and say, "Well, we're waiting, we're trying," and they try to not say that they're not complying with court decisions, even though at times it was the same as flagrant incompliance.
Even though they were doing it blatantly, effectively, it was the same. Go ahead, please, Dr. Fuchs.
I can add that they never bluntly said, we don't respect the court. Maybe we can talk about one specific case about the chairman of the Knesset, Edelstein, a few years ago. And after a few days, he did resign from his seat. So in a way, he did comply because his successor did comply with the court. So it wasn't really a refusal to abide by the court. So the issue that we have today, when the prime minister is suggesting that he won't listen to the court on the constitutional matters that we deal now, this will be a precedent. This will be the first time that the government, if it will happen, I really hope it won't, but it might be the first time that the government would just say, well, we don't listen to the decision of the court.
I see. We're talking about decisions of the court, which brings me to something that I read, and I want to make sure I have it correctly. Annually, how many decisions does Israel's Supreme Court hand down?
There are about 9,000 decisions that the court hands down each year.
Not too much.
No, not too much. I'm laughing because that number is just mind-boggling.
Well, some decisions are made by single judges. So we have about 6,000 of these decisions, more or less, are handed down by a single judge. And the rest of the 3,000 cases are handed down by panels of judges. Usually the court sits in panels of 3, and really important cases such as petitions to invalidate laws or basic laws, the court may sit in wider panels. It has 15 justices on the bench, but usually the panels are panels of 3, and so it can somehow manage such a caseload.
This is so different than
may add another explanation.
Please do.
You have to understand something very unique about our Supreme Court.
Mm-hmm.
It's the first appeal on the first instance on a very wide, many cases. They start on the district court, which we have about 6, or maybe I'm wrong, guys.
6, yes.
We have 6 district
courts. And your
courts.
district courts are above magistrate courts.
Yes.
Okay.
But important cases, grave offenses, and big lawsuits start at the district court, which means that the Supreme Court is the first appeal, and it is a mandatory appeal. They don't choose their cases. They have to listen to a very long and very big and complicated cases every day. In cases of murder, cases of big lawsuits about every field of the law. And this is why this court is very unique. It's not a constitutional court that chooses like 100 cases, which are very, very important and constitutional issues. they deal with day-to-day people. They deal with many, for example, appeals about what is the penalty. Just it. I worked on the attorney, on the prosecutor, the state prosecutor. Hours and hours, days and days, the Supreme Court is just dealing with really relatively not important and not big issues about should this man go to jail for 2 years or for 3 years, or just about these issues. So this explains why this court, and maybe we will talk about it later, why this court is very professional, and why all the talks about this court should be more political and this court should reflect the majority and all that. In a way, you have to understand that this is a very different court than the American court and than most of the Supreme Courts, just because it deals a lot with just regular cases as a first instance of appeal. It does have also a few thousand, how much, Guy? 2,000 cases of what we call bagats, a petition for High Court of Justice, and this is kind of a constitutional court. But it does have thousands of cases which are just first appeal.
I have so many questions now. Okay, let me just say it this way. I used to practice law. I was a patent lawyer, and of course went to law school and learned about all sorts of legal subjects. In the U.S., legal scholars and legal historians live and breathe the Supreme Court's decisions, which are about 100 or so. There used to be less. Now there are a little bit more. That jurisprudence is important. In a specific subject, let's say civil rights, patent law, whatever, they could just list the name of important cases. How does that compare? How does that level of scholarship compare to Israel when you have 9,000 annual cases? Do they pick, do they go to that 3,000 that's more important, as Dr. Lurie was saying earlier? That volume is just so huge.
Well, it is a huge amount of cases, but again, let's say the High Court of Justice cases are about 1,300 cases a year, sometimes more. But again, yes, it's I guess it is more difficult. But I think in terms of the really important public cases, the amount of cases is probably not that different in terms of the really important matters that come to the court, because really the court does not pick and choose. The court doesn't choose which cases to hear and which not. It has to hear all of the cases. It can, in cases that it thinks that don't have merit, or and they don't, the petitioner doesn't have standing, or it may brush off the case, but it has to give a decision in each of these cases. And so the really important cases, I guess, in each field are not that different, probably.
Are not that many. We're talking about cases and decisions, which brings me to this final question of this segment. Can the Knesset ever take away the Israel Supreme Court's jurisdiction on a case? Let's say you and I sue each other, we go before the Israel Supreme Court, and the Knesset said, nah, you don't have jurisdiction to listen to this. And by the way, I asked this question because the U.S. Congress has actually done this. They have taken away the U.S. Supreme Court's jurisdiction on a pending matter. They did it in 1868, and based on many legal scholars, they still have the power. They just don't exercise it. You could see the political backlash if they do that. So let's go back to Israel. Is this a possibility?
Yeah, you're me.
I think in terms of types of cases, we already have, in terms of the Knesset, Israel's parliament, bringing some of the jurisdiction of the Supreme Court to bring some of the cases down to the district courts. There is a process in which, especially administrative law cases, certain segments of it are being brought down to the district courts. And other types of cases also, over the years have said no, there is no jurisdiction, for instance, in appeals against the president of Israel, which is a symbolic figure. Although the court, petitioners and the court have found a way around that, let's say, negating the jurisdiction of the court.
So that I'm clear, in this case, the Knesset actually did try to take away jurisdiction on a case pending before the Supreme Court about
take away the jurisdiction of it as a first instance. You should understand, maybe we didn't clarify it enough earlier. It's another unique issue that all the petition to the High Court of Justice, you go straight to the Supreme Court as the first and last instance.
Yeah.
So what the change that the guy is talking about, some of it is taking away this jurisdiction as a first instance and give it to the district court. The appeal will still be in the hands of the High Court.
Okay, so it's different, and the
not
appeal will still go
anywhere.
up.
It's just screening some of the cases and in the way the court wants this, because they are packed with thousands of cases, and they want that some of the cases will start in lower courts in order to have them less packed.
I see. Let's take a break here. We'll be back after a short break to talk about how Israel's judges are appointed, and also to answer this question: what is this reasonable standard that is so much on the news right now? We'll be right back.